Thus far, we've considered courts reviewing agency actions for constitutionality, for compliance with congressional enactments, and for compliance with an agency's own regulations. But other issues arise under Chapter 7 of the Administrative Procedure Act. These issues generally don't implicate the court-made judicial review standards, such as those arising out of Chevron USA, Inc. versus National Resources Defense Council, Inc., Bowles versus Seminole Rock and Sand Company, and Auer versus Robbins. Instead, they arise out of the APA. However, when a federal court assesses an agency's interpretation of a statute that Congress charged the agency to implement, the court generally will apply the court-made deference standards rather than the APA. The APA's judicial review provisions apply to the vast majority of federal agencies that engage in rulemaking or adjudication. However, Congress has clearly exempted a few rulemaking agencies from such judicial review. For example, Congress exempted judicial branch agencies from APA judicial review. So, Chapter 7 doesn't apply to the U.S. Sentencing Commission sentencing guidelines because the Commission is an agency of the federal courts. The APA authorizes reviewing courts to set aside an agency's actions if they're arbitrary, capricious, or an abuse of the agency's discretion. This applies to regulations promulgated after formal or informal rulemaking or orders issued after adjudication. Such review looks at the procedural, fact-finding, and policy-making aspects of challenged agency action. The Supreme Court has held that, under the APA, courts must consider first whether the agency acted within the scope of its authority, second, whether the agency's actions were arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with the law, and third, whether the agency's actions met the necessary procedural requirements. This is known as hard look review.